terms of multipliers for continuing with the arrangement. And in our previous discussion, as we looked at the options, you said, well, one way that you can deal with this is to go to court. And so what I want to do now is just, if I may, test out the court option for you. It's really the alternative to doing a deal. And one of the jobs I have as a mediator is to make sure that when you make your choices, you base them with all the information available to you, you need to have. I can walk away today, in fact, we'll walk away today. It doesn't actually matter to me whether you do a deal with Rubber Seal or not. Obviously, if you did, from your point of view, I would maybe feel good about it. But ultimately, I'll wake up tomorrow. It's just another mediation for me. So it's very much your responsibility. And what I'm trying to achieve here is some reassurance that I have done everything that I can do. So the next few minutes are an exercise, or a series of exercises, which I'm going to do. I'm going to give you something to think about and some choices perhaps to work with. You're the Rubber Seal, you're the Benroyce. You look as though you're going to burst out laughing any minute. Is that just your face? It's not interesting. Sorry, I was character for a second.
I wasn't about to burst out.
So that is really interesting. Can we just go back a second?
Should I try and get a different one?
No, it's extraordinary. That. So let me go back. You are the Benroyce chief executive, and you're Benroyce's lawyer.
Yeah.
I think we'll say solicitor rather than QC just in this case, because you'll know more about the facts and the cases and the costs and so forth. So what I'd like to do is to assume that that Rubber Seals stay where they are, playing hardball, and you continue to think to yourself, well, actually, we may just have to go to court because we can't do a deal. Let's work out what's going to happen if you go to court. So, Angela, you were better placed perhaps than Rosemary as Rosemary's advisor, so I'm going to rely on you to provide me some of the information here. So let's look at the court. I'll call it an option. It's obviously the alternative to doing an agreement. And what I'd like to know is, first of all, how long will it take for this case to get to court?
Well, we've raised the action in the court session in the commercial court.
Yeah.
And we understand Lord Tyre is taking control of it. And so
Tyre's not extraordinary.
Yeah. And so he should, he's gone back into the commercial court for this case. And so he has got quite a free diary and he can move reasonably quickly, but probably it'll still take a year before we're at full hearing.
Yeah, okay. So I should put down 1 year. Okay. And assuming that nothing has happened between you and Rubber Seal in that year, Rosemary, you're waiting for this to come to a court, what will the business do in that period of time?
We won't be able to sell any cars in that time, so it would be disastrous for us.
Right, okay. Well, let me just note that just as a feature and put your word up, disastrous. Can you quantify that financially, roughly?
I guess I would say we would lose about £8.4 million.
Really? Right, okay.
Certainly the financial director has estimated that, and that's...
So if I just put up millions, okay? This is rudimentary. There's nothing, no particular science about this. At any stage you can have a look at my God and say, well, that's just rubbish. You've got to rely on your advisor in this. Okay, and that's 1 year until it gets to what we call in Scotland a proof, or a trial of the facts.
Full evidential hearing, and then we would hope there's a rule of thumb that the judge will issue his opinion within 3 months, and we can ask him if he can do it as quickly as possible. But there's no strict time limits, so if he doesn't do it in 3 months, you can write to the court and ask them to speed things up, but there's no guarantees.
So let's suppose that he finds in your favour after that 3 months, so that's a year and 3 months from now. What then happens after that?
Well, we would succeed, but then there's obviously always the possibility of an appeal. And the other side could take the view that there's flaws or issues with his decision, and they could intimate what's called a reclaiming motion. That'll go in front of 3 judges. Now, at the moment, things aren't taking quite so long to get into the inner house, which is 3 judges, but it would still take a matter of months, minimum.
Roughly?
Well, it's difficult to say at the moment because of the effect of court reform, John. Things are moving quicker, so let's say another 4 months.
Okay, well, we'll just leave that. I mean, what we're getting there is you're getting towards 2 years, not quite 2 years, but it could be 2 years. Suppose there's no appeal. So I should be careful. I said could be 2 years. What you're saying is a year plus 3 and possibly 4. Let me not innovate on that at all. Suppose there's no appeal and you have a judicial decision in your favour. What happens in terms of implementing that?
We would get a court interlocutor, which is a decree, and then we would have to enforce that against the other side.
And just for the lay person, and actually I forgot about all these, what would that entail?
No idea, I'm not a solicitor. You would have to serve the decree through sheriff officers or messengers at arms on the company where they are, and then try and recover their assets. Now, depending on where their assets are or the nature of the assets, that could take, it's how long is a piece of string, that could take a while.
And as you mentioned assets, what does that assume?
It assumes they have assets, which again is something that we are not entirely clear because they've not been lodging their accounts with Companies House.
So there is going to be an issue about can I put our solvency might come into account at that point?
If they go out of business, they won't have any assets and you won't be able to recover the money. So you'll have a decree, but you won't actually be able to get the money to satisfy that decree.
Now can I just pause for a second? Rosemary, all I'm doing here is just trying to work through with you what the consequences are of this particular option. It's part of this, just a check. So that you've got some really good objective criteria against which to assess what to do with rubber seals today, difficult though the present situation is, and I know that. So let's assume then that you go through the court process and you go through whatever you have to go through in a year's time. What I'd like to do, I think, now is to look at some of the costs of that. Obviously there are business costs. But just in terms of direct outlays, the direct costs of going to court, can you estimate roughly what it will cost to go to court? I mean, well, the first question is how long does this take? It seems quite a complicated case. I don't know how many days in court, how many weeks in court, from your experience?
We are not at the stage of being in a position to assess how many witnesses would give evidence because I don't know what the defender's evidence would be. But from our perspective, our preliminary consideration, we would say maybe 4 days would be sufficient. But we've got senior and junior counsel acting in the court session, so the expenses will be substantial.
So suppose you're saying 4 days, would it be irrational to suggest that it might, on their side, take 4 days as well, make that as an assumption, a working assumption?
It could be a working assumption. In the commercial court, as you know, they might use written statements and make submissions, so they could try and reduce it.
Okay, so give me a ballpark number of days, just from your experience. This is no more than a rudimentary against. Obviously, nobody's bound by this.
6 days.
6 days. Now, you mentioned senior and junior counsel. So, what's that going to cost per day?
Senior counsel will be $3,500 to $4,000, and junior will be $1,750 to $2,000 a day. And that'll be negotiable. All council's fees are negotiable.
So the sounds as though it's 5 to 6k per day?
Yeah. And that's not including court fees as well,
So
which have just been increased.
What about the solicitors?
They'll be $350 an hour. We've got a really good solicitor.
Right.
Oh, that's me.
So are you charged on a basis? So how many hours a day? 8 hours a day? 10 hours a day?
We should have asked you this. He's
I
got
know,
a much better idea.
I had to let him go, and I'm sorry. I know. So let's just assume 8 hours a day, 25, 40, it's about 3,000 a day. Actually, that is what I hear most days.
All right, yeah.
So if that's 3, you got court fees or what?
Well, court fees have just gone up. So in the court session in the outer house, it has gone up to
Let's say 1K.
200 per half hour per party, so that's 400 per. So it's quite substantial.
Just for the sake of this, what we've got here is you've got like 10K a day.
Easily.
Easily.
That's just your costs.
What about preparation?
That's separate. These are court days.
What about preparation ballparks?
And to get to that hearing, you will have a lot of smaller hearings, procedural hearings, discussions with the judge.
So we've got 60K just for the court itself. I frequently hear people talking about hundreds of thousands of pounds for this sort of case.
Absolutely, quite easily. And that's, we then get into distinction of recoverable.
Well, I want to come to that. So, can I just jump, just for the sake of illustration here too, let's just assume that you tell me that this will cost a minimum of 100K to do. It's just illustrate the point.
Yeah.
So you've got your 100K outlay, and who funds that?
At the moment, our side are paying it privately. They have an insurance policy in place, but it's only going to pay potentially maximum up to 50K.
So you mentioned recovery costs. So if Benroyce win, how much of that 100K is spent do they get back?
It will go to the auditor of the court session, and they will recover judicial expenses. That's expenses that are involved in days in court,
Get all that.
lodging
Percentage
days
of 100K, how much do they get back?
in court.
I'm told
70%.
a maximum 70, I get these days,
Yeah.
Okay. So if you win, you've spent 100, you may get 70 back. So your net outlay, even if you win, is 30K. Just on that example, and that's a very rudimentary example. If Benroyce were to lose, presumably the 100K has to be met anyway.
Yes.
Shall we make an assumption that the other side might have 100K of costs?
Yes.
Well, who knows? And on your analysis, Benroyce would have to pay 70,000
Yes,
back of that.
because even if they lose that, it'll still go to the auditor for the taxation, and
So-
they might have to pay 70.
So the range is between, if win 30K net, in fact, what I should do, negative there, and if lose 170, would be what the company have to pay out.
Yeah.
This is a very rudimentary, I suppose, discussion we're looking about some of the risks involved. For a company like Benroyce, you could probably multiply these figures by 10 in the real world, but we'll just take it on this basis just now. So I want to just leave that sticking there, okay? So even if you win, the best is that you'll be down 30K, and then you factor in the other information that you've given earlier on, which is that we're disastrous in terms of loss of sales, and we're talking about up to a year, all this time in court. Often in this work, and forgive me for using a flip chart, it seems terribly old-fashioned, but it's the only way I can deal with it at the moment. We talk about a number of factors that come into play. So what we've got here is direct costs, and that, if you like, is your 30 to 170 range. We just talked about that. There's obviously the indirect costs, and you talked about millions. We'll just put that there to bind us. What about reputational risk if this is in court and the spread all over the newspapers?
Well, it would have an impact on our reputation in a number of ways. First, that we weren't meeting our customers' orders. Mm-hmm. Second, it would just be embarrassing. And third, uncertainty for the future. Mm-hmm. So people would stop ordering cars from us.
So we've got reputation, and it's interesting. That's almost linked to the other aspect, which is just the whole business of adverse publicity, isn't it? Yeah. What are the other potential costs if if a number of your key people are involved in this process of litigation? What else is lost?
Have a negative impact on the motivation of the company. You know, the staff. It would have
So you got motivation.
a massive decrease in productivity
More,
because everyone would
yes.
be taken up dealing with this.
Yeah. Okay, reduced productivity.
Could result in ill health, distress.
And so on. Not unfamiliar.
Good.
And what's interesting for us who've been lawyers, who often thought it was just about the facts and the law, is that in any commercial, any non-commercial situation, there are all these different factors. I've made it very crude quite deliberately. In fact, one of the great things about the flip chart and not having modern technology is you can be really crude about it and just throw these ideas up and they stick or they don't stick.
Yeah.
I think you get what I'm getting at though, is there are all these issues to consider. So that's the next piece of work. The further piece of work that sometimes is helpful is to do what we occasionally call a decision tree analysis. And what this does is allows you to work out with Angela what the probability is of success in the court action. That's a risk analysis, I suppose. And I suppose, Angela, I need to rely upon Angela's legal advice here. There are three parts of this. One is the establishing, for this case, to succeed, establishing a contract, that the contract's been broken in some way, and that you'll recover damages as a result of that. So that there are at least these three legs of kind of classic legal analysis. So forgive me for getting into a legal analysis, and what I want to do is to try to make sure that this is comprehensible to us all, but also we need to rely upon Angela's advice because you're in a court process. That's the guy, I can't make any difference than it is. So Angela, what are the prospects of establishing that there's a contract here?
We've taken the advice of Senior,
Mm-hmm.
and there are reasonable prospects, and Senior has said that is between 50 and 55%.
Okay. So let's do 55, just to take that the highest that you suggested. It'd be very interesting, isn't it, because they claim that even if there was a contract, there's nothing which obliges them to continue to supply. So what is the prospect of establishing that they have in fact breached this contract?
Well, there are significant risks. According to Senior, the prospects are reduced. They're about 51%.
51%.
And even then, I think Senior is quite concerned it could be as low as 50-50.
Well, can I just put 50 because actually it's just more interesting and more helpful arithmetically. And then you're making you're not actually making a claim for loss yet, are you? So what in court, what are you seeking to do? Remind me. I think you've gone to court on this, you're raising the action, all right about that?
Yes.
So what are you seeking to do?
They want them to continue to supply
All right.
the rubber seals for 5 years.
So it's a
Plus
technically it will be a
specific
case in which you're seeking to implement the contract. Okay. All right. Well, in which case the third leg of this will just leave out very often. Rosemary, we need to talk about how the money is being sought, how likely is that you just even if everything else is established, how likely is it to establish that. For my purposes, though, the exercise is served by telling me this: that looking at your risk, because the onus is on you as a claiming party to build up your case, it's not a question of averaging out these figures, but actually you have to multiply them to find out what the probability of success is. So very simply, 55 times 50 is what, 27.5? I think. So what Angela is telling you is that you've got a 27.5% likelihood of establishing in a court that Robert Seal should implement this contract. Now, if I'm wrong about the maths or I'm wrong in the analysis, you are perfectly at liberty to say so. And indeed, when I leave the room, Angela to go through this with you, but Angela, these are your figures, and all I'm doing is trying to show you, as the pursuing party, what the probability is. And I can illustrate this point in a further way. One of the great things about using a flip chart is you can just do it in a very rudimentary way. So that's your target. Successful court order in your favour. However, you've got to build all these blocks up to get there. And that's why we've done this, because these are the building blocks. Arguably, at least, all that Robert Seal could do is pull one of these blocks away. So there's an asymmetry about all of this. It's just the nature of the litigation system where, in legal jargon, the onus of establishing your case is on you. In theory, you don't have to do anything. And all we have to do, if you have been able to do all of this or try to do all this, is sure one of these is weak. And that's where your 27% kicks in. So the reason for me doing all of this in a very, very simple way is to take you back then to the option of court, which is what you say you will do if rubber seal don't play ball. What I want you to do when you're making decisions is to take fully into account all of this. Particularly, even if they're successful, they'll still be out in the money. It could be 2 years down the line, and these guys could be bust. But what we're really hearing here from the analysis that Andrew's giving us is the chances of being successful are not high. And therefore it's much more likely that that's going to be the result. And you've still got all of these which apply anyway. Now that sounds as though I'm trying to persuade you not to take the court approach. My job is simply to make sure you're aware of all these risks. I can't make it any better than that. And I've got to leave you in the hands of Angela now to talk about it. What it does mean when the rubber hits the road, and that's literal as well as metaphorical here, a rational, responsible chief executive will need to take these things into account, I suggest.
Doesn't seem very appealing.
Well, that's a conclusion that only you can reach. What we need to do now, against that backdrop, is to find out where rubber seal are.
Yeah.
And what you need to find out is what the best they can offer today. And when you find out what the best is that they can propose to you today, given where you are on this analysis, make some choices. And maybe the most telling thing that I have heard you say is that it would be disastrous even to run this to court, whatever the outcome. There's a benchmark there, isn't there?
Yeah.
Regardless of all the analysis and the costs of court, which in some ways are relatively small, what you said is there are millions of pounds at stake here just going to court, even if you win.
No, it would be. There doesn't seem to be any positives with this option.
Well, again, that's your call. If that's your conclusion, then I suggest to you your job is to do the very, very best you can to optimise the agreement today, if you can get it with rubber seal. And that may mean you've got to do things that you didn't expect. What we're doing here, in a sense, is just looking over the edge and seeing all the things that could go wrong. So I need to get back looking at the horizon again and remember what your purpose is. So remind me what your purpose is here, or restate your purpose in the light of what we've done here in this mediation.
To get the best outcome possible.
And what does it look like you need to do to achieve that?
Come to some agreement with rubber seals.
So I'm going to proceed on that assumption now, unless you tell me otherwise.
I don't think we have another option.
Again, I'm pleased when I'm out of the room, spending time thinking about this, but remember, most of the information here has come from Angela. All I've done is processed it in the way that I know how. Shall we, Angela, any comments on that? Any questions from your perspective?
No, I didn't realise how bad it was actually. And our only witness, our main witness, is currently on a life support machine because they had a road traffic accident last week. I think, although we had Senior's opinion on the prospects last week, I'm now thinking even worse than we're
Is that one of these life support machines with the rubber seals on them?
Let's hope it holds.
Right, well, it is what it is. I often have to say at this stage, I'm sorry I didn't invent the litigation system, and neither did you, but that's the best that society's come up with if you can't reach an agreement about things. So that's why we're here. We're here to try to make the very best of this opportunity. So I'm going to go away. I want to restate and rethink now what we're trying to achieve out of this. And I think, having looked earlier at the options on your flip chart, possible ways forward, what we might need to do now is just gather ourselves in each room and find out what we're each thinking. So why don't we take a break? I'll go and just check up where things have got to in the rubber seals room. When I come back to you, I think I'd like to go back to the analysis we did in the flip chart about ways forward and the criteria. Let's leave the court thing out now, and let's look at what you really need to achieve here, what you really want, what it might cost you. To be crude and frank.
Yeah.
All right.
Well, thank you for your help.
Well, that's all. Thank you for being so gracious in the way that you have